All right, it is April 17, 2025. We are joined today by repeat guest. I don't know if he's setting the record. By the end of his next two appearances, he might set, or
Steve.
they
Seriously,
might be
Steve.
setting the record. My apologies. But yeah, Connie Campbell has appeared before on Borderlines to discuss Section 15 of the Charter and Canadian immigration, the episode that we did on sex workers and Canadian immigration. I'm sure there are others, and they will be joining both on this episode and an upcoming episode to discuss different issues pertaining to security issues in Canadian immigration law. And the specific topic of this episode is a case that Connie wanted to discuss and which has big ramifications on inadmissibility for terrorism, which is, I hope I pronounced this right, Talukder v. Canada, Public Safety and Emergency Preparedness. Connie, thanks for joining us today.
Really nice to be here. Glad to be misgendered immediately following the UK
Right?
Supreme Court ruling yesterday.
What did the
defined
UK Supreme Court say?
They
We're
said
totally
trans
off topic
women.
already, but I'm out of the loop.
They defined trans women as biological men at the top of a very long and annoying decision, basically saying that human rights provisions, when they talk about women, in I think it's just in Scotland specifically, but it's going to kind of fall out across the country. Basically, that any instance of women does not include trans women. So you can discriminate and you can build quote unquote same sex or single sex locations across the UK without running afoul of this provision. It's very upsetting to both me and most members of the trans community around the world because it kind of spells doom for trans rights in the UK. We'll see what happens. The consequences are going to shake out really interestingly. But sorry,
Is that
we're
similar,
way off
before we
topic.
do get on topic, is that similar at all to the Trump executive order, or does it have similar ramifications? Because there's been a lot of talk, and we may do an episode on it, about an increase in transgender people looking to relocate to Canada.
Yeah.
I have had that conversation with so many people.
Yeah.
I think the quirks of US federalism are such that the executive order doesn't actually have a lot of weight on kind of domestic legal interpretations of their equality provisions as far as it is right now. The decision written by Justice Gorsuch a couple of years ago that basically says that discrimination on the basis of status as a transgender person is discrimination on the basis of sex. And so you are protected under the existing laws of the US, both federally and then a lot of state constitutions have similar protections. So
I think we do need to have an episode on this actually, because this whole question about I've been messaging Connie lately about gender markers and Canada's issues around not being able to deal with changes of gender markers, and just about people seeking to come to Canada for protection because of what's going on in the US and how Canada is going to deal with what is likely to be an influx of refugee claims by trans people from the United States, and how's Canada going to shake out on all of this, and just what are your feelings about how secure do you feel about how that's going to shake out in Canada based on other supposed democracies dealing with these sorts of issues. It doesn't feel like a safe time much of anywhere, but
I have had this conversation. Like I said, I've done like a number of media requests on that lately. I've shown up on CBC Radio next week to talk about this. I'd love to come back and do this. Make me your permanent third co-host.
We could. We'll see how many episodes it takes for me to gender properly.
Exactly.
That's a terrible joke. But speaking of terror, we're going to segue back in. This was all in an effort to get a segue comment in.
Seriously,
let's talk terrorism. It sounds pretty straightforward. Canada does not allow terrorists. They're inadmissible to the country. Why don't we start with what will hopefully be an easy question to answer? What's a terrorist? How does Canadian immigration legislation define terrorists?
Canadian immigration legislation notably does not define terrorist. And
Oh,
this
imagine that. Oh, imagine that.
But that could lead to inconsistent
debate.
decisions.
Oh, what?
Okay, enough. Like, Connie, why don't we get in? I don't know if you want to do the facts first to kind of set the example of how the law may apply,
Let's
or
talk
the
the
definition of
Talukder
terrorism.
case and just kind of place it in context of kind of recent FC jurisprudence. So there has been a number of cases at the Immigration Division alleging that persons, usually refugee claimants against Bangladesh, are inadmissible to Canada and thus ineligible to make refugee claims because of their membership in the Bangladeshi National Party, one of the functionally two political parties that exist in Bangladesh. And I've lost both.
No, we're here. You're set up on a single screen.
That's very distracting. Effectively, the party is believed to have engaged in terrorism by calling for nationwide general strikes, particularly in the couple of years leading up to the 2014 election and through 2015, particularly the anniversary of that election, that was marked by significant amounts of political violence on both sides. The biggest issue in these cases, and there's been a tremendous amount of divergence in federal court jurisprudence on a number of issues. What it comes down to in Talukder is about the proper interpretation of the specific intent requirement of terrorism. That is, did the Bangladeshi National Party leadership structure intend for there to be acts of terrorism carried out during these general strikes? And to not get into the weeds of the evidence in these tribunals so early, suffice it to say that it really hinges on the reasonable foreseeability of violence and whether the degree of a knowledge requirement on the part of those officials calling for these strikes to actually know that there would be violence, particularly enforcing blockades on transit. So they would set up barricades at various transit locations, and there were instances of petrol bombing of buses that were seen to be violating the blockades. These were very significant acts of violence, as many as 20 people killed in one instance, or one kind of period of one of these general strikes. I have a lot to say on the branding of this sort of political violence as terrorism as it applies to Canada's non-refoulement obligations. But for the purposes of Talukder, it was sort of a case that attempted to harmonize, or at least establish whether a particular immigration division decision reasonably applied this specific intent requirement to the definition of terrorism. And circling back to your first question, Steve, there are sort of two sources used by the ID consistently in establishing the definition of terrorism. One comes from Canada's Criminal Code, and one comes from the International Convention for the Suppression of Financing of Terrorism, quoted in Suresh, 2002 Supreme Court case, which defines terrorism as an act intended to cause death or serious bodily injury to a civilian or any other person, not taking an active part in the hostilities in a situation of armed conflict, when the person of such act, by its nature or context, is to intimidate a population or to compel a government or an international organization to do or abstain from doing any act. So terrorism is an inherently political act of violence against civilians.
Just going to switch it back to group layout. And also for those watching on YouTube, I am going to pull open the case as well so that we can flip along inside the case. I think the first thing that comes to me on what you've said is there's sort of two components. There's this definition of terrorism that comes from Suresh, and then whether or not a political party calling for a protest that leads to violence fits the definition of terrorism. And one of the things that we were talking about before we got on air, and one of the things that is frustrating for anyone who has dealt with these issues, is that the immigration division in the federal court is sort of all over the place as to whether or not membership in the Bangladesh National Party constitutes membership in a terrorist organization. Do you want to maybe talk about kind of how it's even possible that we get to these multiple interpretations such that, well, I don't know, if somebody came to you, Connie, and said, I was in the Bangladesh National Party, would you say, that's it, you're inadmissible? Like, how do you advise them as to the process that may unfold?
It's impossible to advise them on whether or not they'll be found inadmissible, exactly because the federal court and the immigration division has come down on different sides of that question in a number of different cases. And it's not limited only, this issue of divergent jurisprudence on terrorism specifically is not limited to the BNP. Particularly the Egyptian branch of the Muslim Brotherhood, whose name I forget, has a really similar divergence. It's less apparent in the federal court case law, but is definitely an issue at the immigration division, and particularly in CBSA practice across the country.
Does that even vary CBSA office to office or officer to officer?
Yeah, definitely. I think more office to office, because my understanding is that approval to bring these charges of inadmissibility for terrorism is done at the manager level. So it really just depends on who's in charge of the local national security unit. For example, if you were making a claim against Egypt, who absolutely were persecuting members of the Muslim Brotherhood following the fall of the Morsi regime, or Morsi government, democratically elected Morsi government, I should say. If you claimed in Toronto for at least a period, you would be waved through, you'd get to a refugee hearing, and you would generally, if found credible, have your claim accepted. If you filed a claim based on membership in this political party in Vancouver, the local office here found that to be membership in a terrorist organization and would bring those allegations, and in many cases were successful in finding people inadmissible for membership in a terrorist group. This practice, I think, raises really serious concerns around the rule of law, and I'd point viewers and listeners to a really good paper by a previous Borderlines guest, Simon Wallace, Persistent Discord, the Adjudication of National Security Deportation Cases in Canada, 2018 to 2020, that goes through the BNP issue in a lot of detail. But as Wallace points out, and as I think it could be clear to anyone, there's a really serious issue of this lack of comity in the immigration division, and I would say sort of in the area of prosecutorial discretion or pseudo-prosecutorial discretion on the part of CBSA to be treating these very like cases so differently based on, and Talukder goes into this, really similar records. So CBSA has kind of a roster of documents that they file against people accused of being members of the Bangladeshi National Party. And those documents are just used and interpreted differently by different decision makers as to how much intent or knowledge can be ascribed to members of the BNP leadership as revolves around these hartals or general strikes and the violence that ensued.
I think even the way that you described the way that things will differ just even at the stage where a matter is before the RPD, the Refugee Protection Division, where somebody will be making a claim, the minister might decide to intervene based on their claim that they're being persecuted because of their involvement, or even they might have been a member of the BNP or the Muslim Brotherhood, and then tried to leave that group. And because of their efforts to leave that group, they were being pursued by that group. But that involvement at one period of time might still be the thing that causes the minister to intervene and then to try and make an allegation against them as well. Maybe, if you want to talk about that, and because I think sometimes that also is part of the inconsistency and when that ends up, and just the kind of absurd results that can sometimes happen. You're trying to actually withdraw from a group, and still that can give rise to an allegation on these grounds.
Yeah, of course. So in Mr. Talukder's case, that's exactly the case. He is making a claim against Bangladesh for a failure to protect him or to offer operationally effective state protection against the Bangladesh National Party because of a dispute that arose following his exit from that party.
Yeah.
That raises the biggest issue, or one of the very large issues in these provisions, is that their membership is not time limited, and membership effectively need only be at some point after or during a period at which that organization engaged in terrorism, and even extremely long after. Like in terms of the Muslim Brotherhood, they'll usually talk about like they'll say the Muslim Brotherhood has been a terrorist organization since they assassinated the Egyptian prime minister, or attempted to assassinate the Egyptian president. I can't remember.
Sadat or Nasser?
Sadat.
Sadat.
Did they get him? I actually.
I can't remember. I know Sadat. I think Sadat was assassinated.
Yeah. But these things are when you look at something, there is some jurisprudence about whether an organization has made a fundamental change, and I've made these arguments in some cases about political parties such as the PLO or the PA in Palestine, whether or not there was a change following the Oslo Accords, and then maybe a reversal or a backing off in the Second Intifada, whether the PA was directing some of that through Black September or other organizations, becomes a really interesting question of fact. But the core here is a terrorist organization. In this case, the BNP is really accused of quote unquote terrorism only for a period between 2012 and 2015. And this is a political party that has been around since the 70s and has been in and out of power in Bangladesh. And all of the context of the history of this organization, the fact that they were protesting an election that they effectively had themselves barred from and then had to boycott, like it was a very the history of Bangladeshi politics is extremely interesting. The big split between these two parties is that they were on opposite sides of the Bangladeshi civil war, with the BNP somewhat contradictory, opposing independence that the Muslim League, or the Awami League, was fighting for, and it really comes down to whether or not they should be independent of Pakistan. And this flattening of an organization into this 3 years of political violence, particularly for somebody like Mr. Talukder, whose membership in the organization was almost entirely prior to that. Steve, I don't know if you want to pull up the decision, but at what's the actual paragraph? Paragraph 3, there's a good factual summary of exactly what's underlying this, but effectively, he had some involvement with the student wing in 2004, sporadic and casual, and then in 2009, he became a formal member of the BNP's youth wing, worked as a treasurer for a subdivision of that organization, and then quit 3 years later in February of 2012, quit that position at least. He says he quit the organization entirely. The ID finds that that's not credible, that he had membership, but it was quote unquote inactive. So during the period of violence between 2012 and 2015, where they're actually kind of crystallizing this idea that the BNP was a terrorist organization because of their use of these general strike tactics and the violence that resulted from it, I think does a disservice to the overall objective of these provisions, which is to prevent terrorists or people who are members of terrorist organizations from coming to Canada. This person was a member of a political party that called for violence or called for general strikes, which in turn resulted in violence. And there's an issue to my mind of causality and actual proximity between membership in this organization and any kind of actual individual culpability for violence, for terrorist violence,
I mean, I think
even
you're
if
raising
you
two.
find that the organization did commit quote unquote terrorism.
Yeah, I think there's two interesting issues that you raise, and maybe we can do like, I don't know, 10 minutes-ish on each. One, is this terrorism? Calling, I mean, I noticed you corrected yourself when you said calling for violence, then calling for protests that led to violence. Is that terrorism? And then number two is just how broad, like someone being in the student wing of that organization. So let's sort of start with this issue of like, and I think this kind of gets into a little bit of the specific intent issue and everything of, is it terrorism to call for protests that lead to violence? Because you can start to see, and whether or not, like, is there a willful blindness? Do you intend the violence? Because you can start to see all sorts of scenarios where people may call for protests on different things and violence ensues.
It's about sort of reasonable foreseeability, it seems. It's not, I think that my read was that willful blindness is not sufficient, but that if the violence is reasonably foreseeable, then according to Suresh, that does constitute potentially an act of terrorism if acts of violence are reasonably foreseeable.
Yeah, and the record here, that becomes such a case-specific issue, and it becomes what's on the record. In this case, they look to statements of the chairwoman of the party, which they found both insufficiently condemned the violence and called for further strikes even after violence had occurred, knowing that elements of particularly the student wing, and there's less good evidence on this of whether the student wing itself was passing out or involved in the direction to use things like grenades or petrol bombs in the enforcement of these blockades. Because that's what it really comes down to. Like, the act of violence against civilians is in the enforcement of these blockades, particularly like blocking roads and transit and preventing people from riding buses. And it's hard to say that the petrol bombing of a municipal bus or of a private taxi bus service isn't an act of violence against civilians along the Suresh definition. The issue is that act directed by or is there some causal link, and is there some knowing foreseeability on the part of the Bangladesh National Party that when they call for these blockades, that they know they will be enforced with this level of violence against civilians? And the reasoning of the federal court on this issue in Talukder, I think, is fairly persuasive. There's been, in terms of whether the immigration division reasonably made a reasonable decision on the evidence before it, you know, I would certainly quibble with the outcome. And if the federal court was sitting in a position of correctness review, I think you could really get in and say, you know, they overread the provisions on knowledge that require, basically, that allow judges or juries to make reasonable inferences from conduct. Basically, there's jurisprudence in the criminal context about sort of how you're allowed to reason around specific intent requirements. And I should say that basically their criminal offenses are divided into kind of two categories as regards the mental element that is needed to be shown, particularly whether you need a generalized or specific intent. specific being you have to basically intend for your actions to cause the harm in question. And in this case, when it's something more like aiding and abetting of terrorism, whether you and they don't actually get into this in the case, but I do think that an aiding and abetting framework here is probably more accurate, and should have been applied and probably should have been argued. I've got another case on aiding and abetting in a 1FB context, but that's a totally different question, so it's kind of fresh or top of mind. But that, yeah, it's exactly this quote from the Seymour decision that you've got on the screen, Steve, about the inference that you can draw and the kind of reasonableness of those inferences. But it's not really for the federal court to be parsing or reviewing those instances other than on the Vavilov standard. The issue on appeal is going to be whether, and it gets very kind of difficult to parse this stuff, but looking to the certified question, they ask, to the extent an organization's specific intent is required to support a finding under 34.1c and 34.1f of IRPA, that is terrorism and membership in a terrorist organization, basically, is the legal and analytical approach applied by the immigration in this case reasonable, and if not, must the applicant's alternative proposal be accepted? And the alternative proposal in this case effectively is an argument on the part of Mr. Talukder's lawyers, and I want to find it exactly in the case. At 64, paragraph 64, the judge describes it as follows. And taking from the applicant's oral submissions, one way to establish specific intent in line with Mason and Waldemarian is for the decision maker to point to specific evidence the BNP has directed its members to not just conduct violence, but direct violence with the intention of causing death and serious bodily harm. Yes, they acknowledge that would be hard to find, but the court has said we still need to point to something. We still need evidence. And this cites to Hussein v. Canada, which is a different, one of the cases that went the other direction. Whereas the decision of Justice Graham and MN and some other cases, such as OPU from Justice Little, found basically that the idea in those cases reasonably identified a linkage between BNP leadership and specific directions of killings and violence through a construal of specific intent along that kind of reasonable chain of what do you think people were intending when, knowing that there had been violence previously, they called for similar blockades to take place.
So a slightly more inferential, like they're allowing more inferential, for intent to be construed on more inferential grounds. Mm-hmm.
And I do think that's where I think what the federal court is, or what the ID is actually looking at is, did Bangladesh National Party officials aid and abet terrorism? Not did they actually conduct it? And is the organization itself a terrorist organization for making these proclamations or calling for these blockades, knowing that some violence against civilians might result? I think that question is messy and actually less interesting, or at least there isn't a serious engagement in the decision with some of the broader implications of Mason and Waldemarian. And I do think that, and again, I didn't see the entirety of the applicant's submissions in this case. I'm very curious to read the submissions on appeal from what's Warda's last name?
Shazadi again.
Shazadi, yeah. From Warda, because she's an extremely good lawyer. But I would say that there's been a casualness with which Mason and Waldemarian have been applied, and I think even in Waldemarian, there's an issue of sort of just taking the holding from Mason, which is that Canada's non-refoulement obligations required a security nexus for a particular
Right.
conduction from 34.1e, which is conducting violence that might endanger persons in Canada, and whether
Right.
that's a security admissibility provision. Well, it is a security admissibility provision, but does that need to be connected to a national security element, or does it just need to be any violence in Canada that endangers Canadians? I think that the lessons to take from Mason run a little bit deeper than that and are really about the appropriate statutory interpretation that needs to be given to all serious inadmissibility provisions that prevent an analysis of whether somebody is going to experience refoulement.
Right.
And I would say that the federal court really drops the ball on this analysis in their decision.
Right. That makes a lot of sense.
Basically saying, well, this guy will get a PRA, you could have ministerial relief, there are these safety valves. And Mason says exactly the opposite, that it's inherent to the definition given by the Immigration Division to these provisions that international law obligations need to be respected, particularly the non-refoulement obligation. That is, you need to either be excluded from the convention or you need to be a threat to the security of the host country to be subjected to refoulement. And if you're inadmissible under 34.1f or 35.1b or all these other provisions, you are subject to refoulement. You are not you get a restricted PRA. You get a PRA that looks only at a risk under 30 or Section 97, which is a personalized risk, not a risk of persecution.
Right.
And that's the problem. The problem is really with the restricted PRA. But because of that statutory context, that means the non-refoulement obligation has to be considered at the stage of inadmissibility, not in terms of somebody's individualized risk, but in terms of the scope of those inadmissibility provisions and who they capture, and they should, to the extent possible, be interpreted in line with these international law obligations.
That makes
and
a lot of
court
sense.
In Talukder basically says, well, Canada also has international obligations about protecting Canada from terrorism. We've signed conventions against terrorism, on and on. But the problem is these provisions should be identifying terrorists and members of terrorist organizations that are, for some reason, actually pose a danger to Canada's security or who meet the international law definition of terrorism. And I get on some level that that's what the federal court is trying to do by being so exacting here. But I think the issue is much broader. I think that Mason and Waldemarian, if you really read them, open up a lot of the older jurisprudence on things like membership and whether it should be afforded these extremely broad definitions. And I think it's important to remember Pushday, the case that defines membership, is an FCA case. It's a case that can be overturned by Supreme Court jurisprudence. And I think to the extent that Mason calls for a re-examination of all of these serious inadmissibility provisions, if you read it seriously, I think you need to open up membership. I think you need to open up the broad scope that's previously been afforded to these provisions and actually start saying, no, these need to be brought to bear against people who are either security risks or could be reasonably excluded, and bifurcate. And the criticism Canada's inadmissibility regime has come under from the UNHCR consistently is that it separates these questions of inadmissibility and exclusion from the Refugee Convention when they should be considered kind of holus bolus as one consideration.
Yeah, I mean, the historic basis and the idea has been that membership will be very broadly defined, and then you can deal with all of this at ministerial relief, which, as we know,
it's not a real remedy.
It's not a real remedy because it takes about a decade to get those assessed.
And Mason says that it doesn't matter, that the safety valves actually are not.
No, I mean, we'll have to also link to the previous episode we did on Mason, which I had said was the most important decision of 2023, I believe, just in terms of how, if it had gone the other way, how broad inadmissibility provisions will be. In terms of like what is a terrorist organization, I've pulled up the certified question that's going to go to the federal court, which is that to the extent an organization's specific intent is required to support findings of terrorism or membership in a terrorist organization, that the organization is engaging, has engaged, or will engage, was the framework applied in the immigration division reasonable, or is specific intent required? I'm paraphrasing what the question was. What I always find weird about all this, like, is this organization a terrorist organization or not? And I'm curious to hear both of your thoughts about this, is that there's a list that Canada has of what the Canadian government has identified as listed entities. And I've always thought that membership in a terrorist organization, or what a terrorist organization is, should be limited to the listed entities rather than people trying to essentially at the officer level and then at the judicial level de facto add entities that aren't listed by the executive through the listing on the listed entities. I'm curious to know your thoughts on, do you think that that would be a more like a better framework?
I think that's one way around the problems that we identified off the start about this unequal application, or this highly discretionary application of these provisions. There are some issues about whether a listed entity creates a rebuttable presumption that that organization is a terrorist organization, or if you just have to defer to the list, and if you want to challenge the inadmissibility of a certain client for membership in some given group, whether you'd have to separately judicially review, as has happened in the UK for organizations like the PKK, whether you have to separately review that designation. It's an interesting question. I think
Has there been a case where they've said where there's been a finding that membership in one of these listed organizations does not result in an inadmissibility? I mean, I think the big one coming up, or maybe not that it's a terrorist organization, but what constitutes membership will be the IRGC, which is the Islamic Revolutionary Guard Corps.
I think
maybe the recent
the listing of
Samidoun.
both, and I think we can get into the IRGC more deeply when we talk about Wahhab, because I think much more seriously than the listing of the IRGC specifically is the designation of the Iranian regime as a whole as a human rights as a regime that has been involved in serious human rights abuses. So it's less about the terrorist organization listing than it is about the 35(1)B.
I mean, the 35(1)B has a specific time frame, whereas the IRGC in theory goes back to at least 19.
Absolutely.
Anyway, we're gonna.
Anyway, I would say that I think that there's a
Samidoun.
reasonable challenge to the listing of the IRGC, but not the Quds Force, for example. Like I think that lumping them as one organization is probably a mistake. I have a lot of opinions on this stuff. I think that listing of the Proud Boys is, I mean, again, I am a trans person, but I think the listing of the Proud Boys was a political stunt. I don't think that they've engaged in terrorism. I think that the listing of Samidoun has extremely serious free speech considerations in Canada, or freedom of expression, I should say. And it's a kind of bank shot where European authorities say that the leader of Samidoun is actually the leader of the leader in kind of exile of the Popular Front for the Liberation of Palestine, which itself is a terrorist group. But I think that contention is not well established, and they're looking at classified evidence and all of this stuff. So maybe there's something that we don't know.
But this is part of kind of where, like, I wish it was limited. I, like you, when I read why Samidoun was listed, it has the goal of the destruction of the state of Israel and establishing a Palestinian state in its place, and they advocate all kinds of activities, including violence. As far as I know, that could just include that chant. I can't even remember, Intifada Revolution, or there's a specific term. From the river to the sea. But, like,
I mean,
all of a sudden you can start like spreading. Like, if that's going to constitute terrorism, then immigration officers can really start. I mean, I did a consult with someone who was part of a club at a university that had an Instagram that was posting similar things that Samidoun might. And she was wondering, would that make me inadmissible for membership in a terrorist organization? And I said, I really doubt it, but I would have a lot more confidence in that if it was limited to just the listed entities.
Yeah.
Yeah.
I think the other thing too is this is what I understand from what you're saying, Connie, and you'll correct me if I'm wrong, is that there's not enough about the provision that requires anything that connects to activity by the member, by the person themselves. It's really too much that is like it's about the definition of membership and the lack of any requirement that the activity of the person themselves is circumspect, as opposed to just the activity of the organization as a whole. That's what's missing.
I think this runs across
Exactly.
34(1)(f). I think there's a really big issue with this associational inadmissibility that exposes somebody to refoulement. I do think that there are cases where you could say that somebody who's not directly carrying out violence or calling for violence is still sufficiently tied to the terrorist activities. And I think I'd like to see a reinterpretation of the membership provision that looks at whether the person actually was involved in planning, supporting, advocating for some kind of actual nexus to a security, some kind of like security event, or you could say like some kind of threat to the lives or safety of civilians in the case of terrorism, or the actual subversion of a government by force, or the non-violent subversion of a democratically elected government, whatever the case might be. It's, I think, incumbent on our national security system or our CBSA inadmissibility system to actually be identifying people who are threats. That's what the international, that's my read of the non-refoulement obligation and the other exceptions to protection under international law, protection against refoulement, requires that level. And I believe that that's been the consistent submission of the UNHCR in a number of interventions in Canada.
What is in the case that you've seen the biggest stretch in terms of membership? I can give mine first just to give you time to think, which is someone who drove an ambulance that was helping people who were revolting in Syria was alleged to have been a member of an organization that was furthering subversion, because this was literally what the officer wrote, by medically assisting the people who had been injured protesting and subverting, they were furthering the subversive activities.
Yeah, it's obscene. Like that's, and it's also completely out of line with Canada's. This gets me to kind of actually a place that I wanted to close, and I think is a kind of food for thought, is that I think there needs to be far more kind of prosecutorial discretion or some kind of obligation on CBSA officers to bring cases in the public interest, to actually think, and I do think this is the issue with the BNP, is that they see it as easy wins and as a way to meet quota. I don't know if they claim to not have formal quotas, but I don't believe them. I think that they certainly want to be seen to be, protecting Canada from terrorism. CBSA is a post 9/11 creation. A large part of their mandate is anti-terrorism or security, kind of cooperating with Canada's security intelligence agencies to maintain the safety of Canada. It's a laudable goal of our immigration regime, but they should be bringing cases against people that they think are actually threats to Canada's security, not people who they think they can stick an allegation on.
Yeah, exactly.
And
I mean, I think the thing that's really sad when we're talking about the international obligations, I think it's not just theoretical. It's that so much of the time, the allegations are being raised against people who have actually truly tried to flee the risk that they're facing because of previous associations, sometimes that they undertook because they were pressured by family members, because they got in when they were very, very young, because of these youth movements within their school structure, and then really tried to leave and could not. And then they are being denied protection. And so I think it's that context. Again, it's not just theoretical.
No, absolutely. And that's where the court would say, and it's not entirely unreasonable for the court to say this, like it's not the court's place to make these policy decisions, but the court would say, well, that's an argument for ministerial relief, right? They're, they were a member, but they were recruited as a youth and they tried to leave. And maybe, it's not quite a duress argument because they didn't leave as soon as they could have, but there are these other kind of compelling humanitarian and other factors that mean that this person isn't actually a danger. To the security of Canada, or in the case of other inadmissibility, to public safety. So I think that CBSA as an organization and IRCC2 in some cases need to actually be thinking about their obligations to be a relief valve themselves and to think seriously about bringing these allegations, particularly when somebody could be subjected to persecution, to refoulement to persecution, that is deportation to a place where they have a serious risk of being persecuted for a convention ground. They need to
consider
think about
things like coercion. Yeah.
And they need to think through whether this person is a risk and whether this person, deserves to be tarred with this brush of this label of terrorist. Like, and I'm trying to think of how to best describe this because I think all of my weird examples are either cases that I've eventually won, or but
I mean, if you won them, they still brought the argument.
They still screw up people's lives for 4 years. I have a lot of concerns with charges of subversion for members of the KDP or other Kurdish groups, because again, any stateless group, Palestinians as well, like any group that is rendered stateless, advocating for their own national self-determination, as should generally be their right under the UN Charter, is deemed to be subversive because they're inherently pushing against whatever is the internationally recognized authority over the territory that they're claiming for themselves.
Well, that was Edelman used to always say Luke Skywalker would be inadmissible.
Absolutely, and it's any quote unquote freedom fighter or somebody who's just advocating for self-defense. The allegations launched against members of the Cameroonian Anglophone minority who are effectively being subject and to or were for a time a quasi-genocide, or certainly an attack on their language rights and their existence as a separate community within Cameroon. Anyone associated with even the peaceful civil society groups that were opposing the shuttering of Anglophone schools and things like that were tarred by a single act of storming into a radio station armed. Fair, no one was hurt, but they took over a radio station a long time ago too, I think in the 90s, and that's the only act of quote unquote violent subversion that then people fleeing 20 years later to come to Canada to make refugee claims because they're being shot. And there is now extremely violent suppression of the Anglophone minority in Cameroon, that anyone associated with any political organization for the rights of Anglophones in that country ends up with allegations of security inadmissibility for membership in a subversive organization. The same thing happens with effectively any politically engaged Palestinian, because the PLO is considered a terrorist organization because they implemented guerrilla tactics in the early days. I would again argue that post-Oslo, there's a genuine change in the nature of the organization.
They went. I mean, there's a case on this where they went after someone who was a member of the Palestinian Authority, at the same time that the Canadian government was saying that's the entity who we want to work with.
Absolutely.
In the Middle East.
Yeah, no, and I've worked on some of those cases, and I find them extremely troubling because they're so counter to Canada's actual stated policy goals. So CBSA is effectively running counter to what our own foreign policy is, both historically and presently. And I just don't understand why somebody in government isn't putting clearer directives to these local national security offices on who to go after and who not to.
So you think they want easy wins?
I think they want easy wins. I think that there is obviously, if you look at the list, people have said this, there's a bias against any kind of Islamic organization, in part because of CBSA being a post 9/11 organization and the focus on Islamist violence or whatever you want to call it, terrorism, yada, yada, yada. It's an understandable bias in the context of Canada's history, but it's still clearly a bias in that list of designated organizations.
Mm-hmm. I think it's also an auditor general and media pressure that only goes one way, which is like the screening is lax, the screening is lax, the screening is lax.
Absolutely. Every time there's a thing like the man who's alleged to have been caught on tape beheading people for ISIS and then being granted Canadian citizenship, anytime something like that happens, they say, well, we need, CBSA to be harsher and more discretion, how could this
Right,
person
that's a good
possibly gotten
example.
into
That was just
Canada?
last year.
Yeah, so, but
But
I would
also the
argue
applicants, the claimants are providing the information that they require in their own claims.
exactly. It's just easier.
It's easier. They've actually disclosed this information as a way of explaining why they require protection. So they have all of the information that they require to make the case. And the law does not require the state to go beyond and show that there was a specific intent by that person to commit a terrorist act themselves. It actually obviates the need for them to do that. So it's sort of like,
or whether they were even supportive of those goals of the organization.
No, exactly.
Like especially these political parties often are advocating for minority rights, and somebody could join up as a youth and only be involved in that side of things. And unless you can get it to a hearing and show that there's a real schism within the organization, or it was these particular cells that were committing violence without the direction of the civilian leadership, and on, like you end up in these really nitty-gritty kind of parsing of evidence, when it should be CBSA's job to actually look at the facts in front of them and say, is this person a security risk? Do we need to bar them as a terrorist? And I would suggest that if CBSA spent a lot more time actually involved in the background checks of people and picked out actual people who might be risks, rather than just blanket going after people who have what they see as untoward political associations, it'd be a much better use of resources. But they want to be able to turn around and tell the minister that they barred X number of people on national security grounds or on security grounds to justify their continued existence, and to say that they're being an effective organization and effectively kind of fulfilling the public safety mandate of Canada. But it's not a numbers game, especially with terrorism. You want to actually stop those people who could commit acts of violence in Canada, or who are truly so culpable because of their membership in these acts of international violence or local violence, whatever the case might be, that they don't deserve Canada's protection or to be able to enter Canada's territory. Like that is what the non-refoulement obligation about. That's what the convention's actually about. And I don't see CBSA in their behavior as actually having any sense that that is what their public duty is. And I have a real problem with that on a political level. And I do blame kind of successive public safety administrations for not paying any attention to that.
It's sort of a balance of convenience thing. It's like better, it does seem to tip in favor of public safety, but super broadly defined.
Well, they're hiring, or at least Mark Carney is committing to 1,000 more CBSA officers. I think it's to investigate the 2 grams of fentanyl or whatever it is that gets smuggled south. But I'm sure some of that will spill over into this. Connie, it was a pleasure. We have you on again in a month. We may add you as the 3rd host. I'll get my gendering right one day. And this was great. It's always a pleasure to have you on.
It's really nice to be here, and I switched to she for almost everything, so it's easier. You don't have to trouble yourself with the they them.
Oh, I didn't know that it wasn't they them anymore.
It's both. I don't really care. Just
not. We'll end on that. But no, thanks for coming on. This was great. It's for those who don't know, Connie used to work with us. God, 8 years? No,
2018.
2018.
Articles.
6, 7 years ago.
To 2019.
And it was a blast. And then you joined our podcast co-host. So always stayed close. Thanks for coming on. And we have you again in a month to continue the discussion on the slightly different inadmissibility topic, as these also seem to expand. So as we try to push the other way. So thanks again.
Nice to see you both. Looking forward to it.
Take care.